Okay, so I wanted to say, every time that there's something going on, you can count on unscrupulous YouTubers, right? You can really do that. Because they'll always get the ones that are clickbaiting and this and that. So if you heard me in the auction earlier and I said, Jimmy, I'm sending something to you. What I was sending to Jimmy was this person who I've never heard of, never seen before, was in my feed with 8,000, 10,000 people watching, literally showing pictures like you could not believe, sitting in a green screen with crap behind him of drone stuff that's not even happening where he said it's happening, made it appear that the New York City airports like JFK and LaGuardia were shut down, like there was an imminent attack. It was crazy. And people just buy it hook, line, and sinker. They can't think for themselves. It's scary. I'm telling you, it's frightening. It's frightening. It took us 1 second to find out what was going on. You know what airport it was? It was Stewart Airport. Do you know that they were shut down for an hour? Stewart Airport is about 1 hour from me. It's where I took Jimmy when he flew out to Edisto on November 18th. So, really, guys, critical thinking is so important. You cannot underestimate critical thinking. But we're here to talk about the facts. We're also going to talk about Luigi Mangione, the former prosecutor that he wants to represent him in the murder case of the CEO, Brian Thompson. We're going to talk about a murder-suicide out in Colorado. We're going to talk about Jamie Komoroski. She wants a reduced sentence. And we got lots of other things to discuss, so keep it right here. Unless you want a lot of lies. Okay, so let's first talk about the airport, okay? So New Windsor, Newburg, that's where Stewart Airport is. The governor of New York shut down the runway for 1 hour due to drone activity in the airspace. She said this has gone too far. She released that statement Saturday morning. The governor's statement echoes a growing frustration among the tri-state area lawmakers who are demanding answers from the federal government about the drones amid numerous reports of them flying over New York and New Jersey and now even Connecticut. The White House officials have deemed suspected threats from the drones to be not credible and said many sightings are likely just that of planes. The FBI said they received about 5,000 leads since mid-November, but only 100 have led to action. And a representative from the Department of Homeland Security says they're confident many of the sightings are manned aircraft that are being misidentified as drones. Local officials are going crazy over the federal response, especially when the drones were reported over New York City. People of Staten Island deserve answers, and the people of this city and state and region deserve answers of what the heck is going on, says the Staten Island Borough President Vito Fossella. The governor's statement on Saturday also called on federal lawmakers to pass a law strengthening the FAA's oversight of drones. Now, and this is what she said, this is going to quote her. In mid-November, I directed the New York State Intelligence Center to actively investigate drone sightings and coordinate with federal law enforcement to address the issue. and those efforts are ongoing. But in order to allow state law enforcement to work on this issue, I am now calling on Congress to pass the Counter UAS Authority, Security, Safety, and Reauthorization Act. This bill will reform legal authorities to counter UAS and strengthen the FAA's oversight of drones, and would extend counter UAS activities to select state and local law enforcement agencies. Extending these powers to New York State and our peers is essential. Until those powers are granted to state and local officials, the Biden administration must step in by directing additional federal law enforcement to New York and the surrounding region to ensure the safety of our critical infrastructure and our people. The FAA says it's legal to fly a drone during the day or at night as long as the operator is flying below 400 feet and it isn't causing a hazard. But restricting airspace is a problem, and that is what happened at Stewart Airfield. Not exactly. Ouch. Okay, let me take this for a second.
Nothing makes a gathering.
What? So there's officials at Stewart International Airport say they shut down their runways for an hour after the Federal Aviation Administration alerted them that a drone was spotted in the area around 9:30 p.m. A drone. The pictures that I saw on this other site, again, a creator I've never heard of. They may not even be in the United States, okay? You should have seen this. There was probably, it looked like there were 1,000 drones. This is what I mean. But you know what? It gets the views, it gets the money, right? They don't care. They don't care. And this is when there is, here's a picture of New Jersey, not tonight, but a few drones, 1, 2, 3, were shown, and that's Bernardsville, New Jersey. And this shows something from December 5th. This photo was taken by Trisha Bushy in Lebanon Township, New Jersey. So that's what we have there. The runway is not shut down anymore. It was shut down for 1 hour. Okay. Now let's go to Luigi Mangione. So you're talking about, White Angel asked me about Luigi Mangione, if he had a girlfriend, about Tijuana, and all this stuff. No, I've not heard that, but Now I see something from India. Okay, India. And picture, this picture, which I think is from his Facebook before it was taken down. Saying that Luigi Mangione's girlfriend, Megan Harris, along with his parents, have gone missing since yesterday. This was put out December 10th. Okay? Say, I don't know. Do I believe in this at all? No, I don't believe it. Who's the source for this article? It doesn't say. Any Tom, Dick, or Harry can be writing this. This happens so much in true crime cases because there's websites. This is a website out of India saying this. No, I don't believe this. Okay, not unless it's a credible source would I believe that. Now, it says Mangione and Megan have been dating for the past 2 years. They studied computer science at Penn. Megan is currently 5 months pregnant. She was last seen by her friends getting into an Uber. However, it suggests that Megan was arrested. Her backpack contained their passports along with tickets to Thailand. So you heard tickets to Tijuana. Here are their tickets to Thailand. Megan could face serious charges, including aiding and abetting, if authorities think her possession of the passports and tickets to Thailand is an attempt to help Mangione flee. These charges could result in 5 to 10 years in prison. Really, where did this come from? And this was reported on December 10th, and you're telling me on December 15th we don't have it from one credible news source? Carolyn would call that alternative facts. Carolyn would call that fake news until we have something real. Okay, so let's go to some real news about the former prosecutor that he's trying to get to represent him. Excuse me. Okay. He retained a high-profile former prosecutor as his defense lawyer. Excuse me. Karen Friedman Agnifilo is currently working at Agnifilo Intrader, which specializes in complex and sensitive criminal matters. The law group confirmed on Saturday that Mangione retained Friedman Agnifilo, adding that she will not be making any statements at this time. I guess he got rid of that other attorney. Friedman Agnifilo worked as a prosecutor for much of her career before she went into private practice in 2021. For 7 years, she was the second in command at the Manhattan District Attorney's Office. She worked under Cyrus Vance Jr., who was known for going after former film producer Harvey Weinstein, as well as President-elect Donald Trump. At the Manhattan DA's office, Friedman Agnifilo prosecuted violent crime cases, including those that had a mental health component, according to her law firm bio. She also served as an acting district attorney when Vance was out of the jurisdiction. 2 other attorneys from Agnifilo Intrader are representing Sean Diddy Combs. I knew the name. Where he was charged with sex trafficking and racketeering. The murder of the United Healthcare CEO. Hold on one second. sent shockwaves across the country. It also brought issues around healthcare access in the United States into a sharp focus, with widespread anger directed at health insurance companies on social media. On Friday, Andrew Whitty, the CEO of United Health Group, the parent company of United Health Care, said he agreed that the healthcare system is flawed. And he said, and I quote, "We know the healthcare system does not work as well as it should, and we understand people's frustrations with it. We understand and share the desire to build a healthcare system that works better for everyone." He added that Thompson was among those who tried their best for those they serve. When a colleague proposed a new idea to Brian, he would always ask, "Would you want this for your own family? If not, end of discussion." The United Health Group CEO ended his op-ed asserting that Thompson was dedicated to building a more affordable, transparent, and compassionate healthcare, adding that it was those characteristics that he and others in United Health Group will emulate. There were over 2,400 comments before the comment section was closed, and many of the responses were of readers that were unconvinced by Whitty's statements. Among the top recommended comments came from Ralph from Naples, Florida, who wrote, "I have read this twice, and in essence, it says nothing. What is he proposing to change or improve?" Another top comment came from Phil from London. "What happened to Mr. Thompson was tragic, but to describe him as someone who was working to make healthcare better for everyone is just patently false. He was working to maximize profits for the company's shareholders. That is the sole responsibility of a CEO, and it continues to be the main reason why healthcare in the U.S. is completely broken." Okay, so now let us go to that murder-suicide in Colorado. It might be very, very new, and there's not a lot of information, but we'll see. Okay. Okay, a 1-year-old little girl and woman were killed in Aurora, Colorado, of course. Suspected shooter found dead. Let me get it was on the 10,000 block of East Evans Avenue in Aurora, Colorado. So let me pull that up. Okay. There we go there. So police in Aurora investigated a shooting with multiple victims. The 10 1300 block of East Evans Avenue on Saturday. Police say the incident involved 4 people, and it was reported just before 10 a.m. According to the police, 2 people were rushed to the hospital with life-threatening injuries, and the status of those patients remained unknown as of noon on Saturday. One patient, a 44-year-old woman, was treated at the scene for minor injuries. The 2 who were rushed to the hospital and died have been identified as a 20-year-old woman and an infant. The preliminary investigation shows that the suspect, a 19-year-old girl, was located by officers and was dead at the scene. Investigators believe the gunman died of a self-inflicted gunshot wound. What happened leading up to this incident is being investigated. However, investigators say it was related to an unknown family incident and everyone involved is known to each other. Investigators do believe that it was related to some kind of family dispute. All of the parties that are involved today are known to each other, and investigators do not believe there is any ongoing threat to public safety, said the Aurora Police Department Information Officer Joe Moylan. So it was 4 people were involved. 2 were transported to local hospitals with life-threatening injuries. The status of those patients is unknown. 1 patient was treated at the scene for minor injuries. The 44-year-old woman inside the residence had reportedly been shot in the hand. Police at the scene offered medical aid to all 3 victims before the child and 20-year-old were taken to separate hospitals with life-threatening injuries. A department spokesperson confirmed that the child and the woman passed away. When officials cleared the apartment, they found a 4th person deceased with an apparent self-inflicted gunshot wound in the back bedroom. The 19-year-old man, that other report reported it as a woman. It's a man. The 19-year-old man is believed to be the shooter, according to a release from the police department. In a social media post, it said the shooting was related to an unknown family incident and everyone involved knew each other. They said they believe the 20-year-old woman was the baby's mother and the 44-year-old woman is the grandmother, but that information is still not confirmed. We have an immense amount of sympathy for what unfolded here, to the families and to the community as a whole. What happened earlier today is without question a tragedy, and we are trying to navigate right now, and we are still very early into the investigation process on this. So tragic, very tragic, especially right before the holidays. Baby and a young woman killed. They're just senseless. So that's sad, very sad. Okay, and then let's go over to Jamie Komoroski, who's trying to get a more lenient sentence, okay? All right. So Jamie Komoroski, who had a blood alcohol level 3 times the legal limit and who was in a rental car, slamming or going right through a golf cart in Folly Island, who killed a bride right after she was leaving her wedding reception with her groom and 2 other family members in the front of the vehicle, wants a reduced sentence. So Jamie Komoroski pled guilty earlier this month to reckless homicide. You heard all the phone calls we have here. Felony DUI and felony DUI with great bodily injury for the April 2023 crash, and she was sentenced to 25 years in prison. Now, there is a filing that was made on Thursday, and we're going to take a look at that. Okay, we're going to see why she wants this, right? So I'm going to pull up her papers, and this is going to give us some insight. Pull it over there. Okay, State of South Carolina, County of Charleston versus Jamie Lee Komoroski, the defendant Jamie L. Komoroski, through her undersigned counsel Christopher J. Grammacione and Nathan Williams, respectfully request that the court reconsider its sentence issued to Ms. Komoroski on December 2nd, 2024. I was right, White Angel. I said it was December 2nd. Remember you said December 3rd? And I said I have the calls from December 3rd, and you said, well, if they were from December 2nd, they would have been the night before, but I was right. It was December 2nd. Pursuant to South Carolina Rule of Criminal Procedure 29, the motion is made on the basis that the 25-year sentence rendered against Ms. Komoroski for the felony DUI resulting in death count was an unwarranted and grossly disproportionate sentence compared to other prosecutions concluded in this court and the region. Alternatively, the motion is made on the basis that the court gave substantial weight to Ms. Komoroski's failure to participate in the Persons Incarcerated Emerging Recovery peer program, which, as set forth below, was a program which she applied but was not selected to participate. Background and procedural history. On September 20th, 2023, a grand jury returned an indictment charging the above referenced counts against Jamie L. Komoroski. On December 2nd of 2024, Ms. Komoroski pled guilty to all charges filed against her, readily admitting her guilt, accepting responsibility for her actions, and expressing sincere remorse to this court. Following a sentencing hearing, the court sentenced Ms. Komoroski to the maximum sentence available for each count to which she pled guilty: 25 years imprisonment for felony DUI resulting in death, 15 years imprisonment for each felony DUI resulting in serious bodily injury count, and 10 years imprisonment for reckless homicide. The court further ordered that the sentences for each count run concurrent to one another. Standard of review. South Carolina Rule of Criminal Procedure 29 permits a trial judge to retain authority to reconsider a criminal matter upon a timely motion made within 10 days of sentencing. Ms. Komoroski timely files this motion for reconsideration of sentence within the statutorily required 10-day period following her December 2nd, 2024 sentencing. The Eighth Amendment to the United States Constitution, which applies to states by virtue of the 14th Amendment, prohibits the issuance of a sentence that constitutes cruel and unusual punishment. The Eighth Amendment prohibits not only barbaric punishments, but also sentences that are disproportionate to the crime. Okay, so I'm just going to go over that whole thing there. Ms. Komoroski's sentence for felony DUI resulting in death is grossly disproportionate with others issued by this court. In the case at bar, Ms. Komoroski received the most severe penalty permitted by state law for each count to which she pled guilty, and her sentences is grossly disproportionate from other sentences this court and other courts within the jurisdictions have issued, while the gravity of the offense was severe. The court gave no consideration to several mitigating factors presented in this case, including but not limited to Ms. Komoroski's lack of any criminal history or any history of violence, unprotected pleas of guilty to spare the victim's family members from the difficulty of trial and save the state time and resources, absence of intent to cause death, known struggles with alcohol abuse, and remedial steps taken to address her addiction. Genuine expressions of remorse and regret for her actions, history, character, and rehabilitative potential, no prior history of DUI or DUI-related offenses, and complete and unequivocal acceptance of responsibility for her actions. The court is required to equally consider both aggravating and mitigating factors, and as evidenced by the maximum sentence issued against Ms. Komoroski on each count to which she pleaded, such balancing did not occur. Moreover, as more fully set forth below, lesser sentences have carried similar and in some case more aggravating facts and procedural circumstances. Examples are numerous and further illustrate in the attached sentence disposition table attached as Exhibit 1. Other sentences issued by this court evidence the disproportionality of Ms. Komoroski's sentence. A review of sentences issued in other felony DUI resulting in death by this court reveal the grossly disproportionate nature of Ms. Komoroski's sentence. In State versus Shanna Robinson, following a contested jury trial, this court sentenced Ms. Robinson to 17 years imprisonment on June 7, 2014. Trial testimony revealed that Ms. Robinson was traveling 79 miles per hour in a 35-mile-per-hour zone when she crossed the center line, causing a head-on collision that killed the victim. Her blood alcohol concentration was similarly high at 0.15, and testimony established that Ms. Robinson was driving under the influence of alcohol, diphenhydramine, trazodone, and clonazepam. In State versus Samuel Thompson Jr., the defendant, 59, was convicted following commencement of trial and sentenced by this court to a term of 9 years imprisonment on January 9, 2013. Testimony during the trial established that Mr. Thompson, an individual charged with previous intoxication offenses, was traveling at a high rate of speed when his vehicle veered into the center median, striking and killing the victim on I-26. Additionally, the state indicated that Mr. Thompson's blood alcohol level was 2.8%. Similarly, that State versus Mallory Hood, the defendant pled guilty to felony DUI resulting in death, admitting she was driving under the influence when she ran over and killed a 24-year-old motorcyclist in Mount Pleasant. That's right around Charleston. While Ms. Hood's blood alcohol concentration was 0.26, 3 hours after the collision that she caused the victim's death, the court sentenced her to 18 years imprisonment. Finally, in State versus Steve Winfield Jones III, the defendant pled guilty to felony DUI resulting in death after running a red light while speeding in Goose Creek. Earlier this year, the court sentenced Mr. Jones to 10 years imprisonment on March 7, 2024. Other sentences issued in Charleston County further demonstrate that Ms. Komoroski's sentence is grossly disproportionate. Other intra-jurisdictional sentences further highlight the grossly disparate nature of Ms. Komoroski's sentence. Okay, and they go through another case in State versus James Bryson Munn. The defendant pled guilty to felony DUI resulting in death following a collision that killed a minor who was 17 years old. Evidence in the case indicated that Mr. Munn was driving 94 miles per hour, and that was in a 45 mile per hour zone with a blood alcohol concentration of 0.217 at the time of the incident. Mr. Munn was sentenced to 14 years imprisonment. In State versus Matique Trayvon Best, the defendant pled guilty to felony DUI resulting in death for causing the death of 2 victims and was sentenced to 10 years, suspended upon service of 4 years imprisonment. In State versus Thomas Garris, the defendant pled guilty to multiple charges including felony DUI resulting in death following a collision that killed 1 victim and seriously injured 2 others. The state indicated that Mr. Garris had a BAC concentration of 0.162 and was driving 56 miles per hour in a 35 mile per hour zone in downtown Charleston. Mr. Garris was sentenced to 14 years imprisonment. In State versus Lisa Pistolas, the defendant drove at an excessive rate of speed while subsequently intoxicated when she lost control of her car and it drifted into the median and into the victim's vehicle, killing him and seriously injuring another. Ms. Pistolas, who was arrested while awaiting trial on separate DUI charges, was sentenced to 6 years imprisonment with detention credit and then suspended the sentence to 4 years, 8 months. In State versus Joseph Sinclair, the defendant pled guilty to 2 counts of felony DUI resulting in death, 2 counts of felony DUI causing great bodily injury and leaving the scene of an accident. State officials reported that Mr. Sinclair was driving a car with a blood alcohol concentration of 0.226 when he collided with a vehicle operated by a victim who was 30 weeks pregnant. Both the mother and her unborn son were killed as a result, and although Mr. Sinclair was previously convicted of multiple DUIs and was driving on a suspended license, he was issued a 25-year sentence suspended upon service of 16 years. In State versus Jeffrey William Wakefield, the defendant struck and killed an 11-year-old girl while driving in downtown Charleston under the influence of fentanyl, one of the most dangerous substances on the planet. When charged with felony DUI resulting in death, Mr. Wakefield pled guilty to felony DUI resulting in death and was sentenced to 25 years, suspended upon service of 16 years. In State versus Dale Yarborough, the defendant pled guilty to driving under the influence after his actions resulted in the death of a 9-year-old child and causing serious bodily injuries to 3 others. The state indicated that Mr. Yarborough, an individual with a known history of DUI convictions, was driving 109 miles per hour just prior to the collision, had a blood alcohol content of 0.219. Mr. Yarborough was sentenced to 18 years imprisonment on September 6, 2018. In State versus Jose Ramirez Sandoval, the defendant, an undocumented migrant, struck and killed an engaged couple in a head-on collision while driving under the influence. The state indicated that Mr. Ramirez Sandoval's blood alcohol concentration was greater than 3 times the legal limit. Mr. Ramirez Sandoval was sentenced to 13 years imprisonment on June 6, 2024. Something about that, that name reminds me of that. I'm trying to think of how I know that name. I just had like deja vu about something. That's crazy. In State versus Jose Javier Reyes Escobar, the defendant, was also an undocumented migrant, was driving without a license while intoxicated, lost control of his vehicle, crashed into 2 other cars, killing one other person who was 76 and severely injuring 7 others. The state indicated that Mr. Reyes Escobar's blood alcohol concentration was 0.335 at the time of the collision. Mr. Reyes Escobar was sentenced to 20 years with his suspended on service of 15 years imprisonment on April 30th, 2024. Sentences issued in Berkeley and Dorchester counties likewise demonstrate the grossly disproportionate nature of Ms. Komoroski's sentence, explaining felony DUI resulting in death cases in neighboring Dorchester and Berkeley counties only further demonstrates the overly punitive nature of Ms. Komoroski's sentence and how grossly disproportionate it is compared to other cases. In the State versus Brandon Limehouse, the defendant was charged with felony DUI resulting in death after striking a woman who was 21 while driving his car while intoxicated. Mr. Limehouse, who was driving following 3 suspended license convictions, was also found in possession of a firearm. Mr. Limehouse was sentenced to 21 years, suspended upon the service of 16 years imprisonment on September 10th, 2018. The examples of disparate sentences for felony DUI resulting in death convictions are numerous. State versus Vernon McNeil, the defendant sentenced to 15 years, suspended upon service of 10 years imprisonment following a guilty plea on April 18, 2019. State versus Joseph Pickney Jr., sentenced to 15 years, suspended upon services of 3 years imprisonment following a guilty plea on August 3rd, 2016. State versus Timothy Pritchett, defendant sentenced to 18 years, suspended upon service of 6 years imprisonment following a guilty plea on May 23rd, 2019. State versus Jamie Schuler, defendant sentenced to 12 years, suspended upon service of 4 years imprisonment following a guilty plea on April 23, 2015. Dorchester County is no different. State versus Matthew Brett Ferguson, defendant sentenced to 15 years imprisonment following a guilty plea March 5, 2024. State versus Brandon Michael Earwood, defendant sentenced to 10 years imprisonment following a guilty plea on May 11, 2022. State versus Daniel Haynes. Defendant settled to 7 years, sentenced to 7 years imprisonment following a guilty plea on March 15, 2019. State versus Amber Lillo. Defendant sentenced to 10 years, suspended upon 2 years of service imprisonment following guilty plea on September 22nd, 2015. State versus Timothy Murray, S. Murray. Defendant sentenced to 10 years. And then another one sentenced to 12, 10, 10, 10. It goes on and on and on. Again, they say interjurisdictional sentences similarly demonstrate the grossly disproportionate nature of Ms. Komoroski's sentence. So they're going to go on, and they're going to say that reviewing other neighboring jurisdictions, possible sentences of incarceration for death caused by an intoxicated driver further undergirds the fact that Ms. Komoroski's sentence was grossly disproportionate. Alabama, 1 to 10 year imprisonment. North Carolina, 15 months to 229 months imprisonment. Georgia, 0 to 15 years. Florida, 0 to 15 years. Kentucky, 0 to 10. Maryland, 0 to 5. Texas, 2 to 20. West Virginia, 90 days to 10 years. And Virginia, 0 to 20 years. We recognize the traditional motions of federalism inherent to states and the broad authority legislators possess to determine punishments for crimes. However, when comparative factors reviewed in assessing proportionality are considered together, the grossly disproportionate nature of Ms. Komoroski's sentence is plainly evident. This prohibition against excessive and disproportionate criminal sanctions is a constitutional protection for a reason and highlights the essential principle the courts must consider the human attributes even of those who have committed serious crimes. State versus Finley. In this vein, sentences that are grossly out of proportion in the severity of the crime are unconstitutional. Ms. Komoroski's sentence for her crimes is grossly disparate compared to offenders sentenced by this court across Charleston, Berkeley, and Dorchester counties, and across the United States. As shown above, even several repeat offenders possessing more aggravating factors fared better at sentencing, including defendants that sought trial by jury. Guilty pleas are recognized as a significant step towards rehabilitation. State versus Brower 3467 SC. Okay. A plea is a factor that favors leniency for those who acknowledge their guilt, often expressing remorse and thus helping conserve scarce judicial and prosecutorial resources for those cases that merit the scrutiny afforded by trial. Ms. Komoroski, unlike defendants who contested charges and who pled guilty, received no such consideration for her plea expressions of remorse, rehabilitative efforts, and acceptance of responsibility. The United States Supreme Court has recognized the need to reduce unjustified sentencing disparities and to reach out even-handedness and neutrality that the distinguishing marks of any principled system is paramount obligation of any court. Kuhn versus United States. Consequently, sentence proportionality is a bedrock of the Eighth Amendment jurisprudence, and the overly punitive nature of Ms. Komoroski's sentence is compared to similar cases with no weight afforded to her compelling case in mitigation demonstrates the unconstitutionality of her sentence. The court should not have considered Ms. Komoroski's alleged failure to seek treatment via peer due to her ineligibility for the program. During sentencing hearing, the court placed great weight on the fact that Ms. Komoroski did not participate in the Persons Incarcerated Entering Recovery peer program offered at Charleston County District Center. Ms. Komoroski, however, requested admission to the peer program in October of 2023, but was not admitted due to circumstances beyond her control, namely the result of a lengthy waiting list and staffing limitations within the program. As indicated by the letters of support from her AA colleagues, Ms. Komoroski would surely have availed herself of all readily available alcohol addiction treatments available, but she was not admitted after submitted a request while detained. Since it is apparent the court operated on a factual conclusion without evidentiary support on a matter which it placed great emphasis, it is respectfully submitted that the reconsideration of a sentence is appropriate on this alternative ground. Wherefore, for the foregoing reasons, Ms. Komoroski respectfully requests that this court reconsider its maximum sentence, 25-year sentence for felony DUI resulting in death, and issue an appropriate sentence that is not grossly disproportionate and violative violative, of Ms. Komoroski's Eighth Amendment rights. Violates, violative. Oh, I can't, I like to. Disproportionate and shouldn't say violates, violative, okay. I don't know, I'm having, I'm having a mind block right now. Violative of Ms. Komoroski's Eighth Amendment rights. Violative. It's a good thing. No, that just sounded like Martha Stewart said that. Okay, here's all of that stuff. Here's, articles and exhibits all about what they said here. Here's all the cases. This one says, officials charged 20-year-old man with felony DUI and underage possession of something, and it said, yes, there's a point that on the she didn't survive, blah, blah, blah. Yeah, I can't even read the whole thing. It's troopers arrest 18-year-old. Bad sentence after guilty, please. Lisa Pistolas. But for Lisa Pistolas, it wasn't the first time alcohol put her in legal trouble, and the resident of Gemstone Boulevard in Hanahan hasn't been shy about expressing her affinity for the drink. Photos posted on her Facebook page show her sipping from a straw stuck into a margarita glass that she shares with a friend. In wedding pictures, she holds a flute filled with a rose-colored liquid. Another photo shows two men holding her legs skyward as Pistolas drinks from a keg of beer. But in February, a Charleston County deputy spotted her Ford Mustang speeding 17 miles per hour over the limit near North Charleston. The deputy reported seeing Pistolas flicking a cigarette through the window before stopping her. A report listed that Hooters employee blood alcohol level content at 0.12%. The legal limit is 0.08. Now, what are they showing about Amazon? Why Amazon has the cutest holiday accessories. What are they showing? That because there's cups, people are drinking? What the freak is that there for? Pleads guilty. So that's all the cases they mentioned. And then all the states and their sentencing, and then all the states and their drunk driving case law. And that is it. That is it. This one says it looks like Komoroski did put a request in the kiosk for Deodas services in October of 2023. Peer Drug Court. Let's see what this says. Let's look at this chain of command here. Please see forwarded from Nicole Pelosi, Charleston County. Confidential. Yes, she did attempt. Also, if they called it peer in court, she may not have known that was the actual name of the program. They call it DAO, DAS interchangeably with peer around here. Thank you. I will let her attorney know that it was a waiting list and staffing limitation. And it says she was placed on a waiting list. She was eligible, but our services for women were limited due to short staffing and their unit setup. We had a list of women at that time that were waiting for services. We were only working with court orders because of the limitations, and still have to do that because the 8-tower unit is not feasible. Hey, there's your word, Scooter. Not feasible. Is not feasible for the programming of peer. I plan to talk with Jill to see if there's an option to have 8-week DAO DAS groups for 10 women at a time to be escorted to the BC Tower twice a week, hopefully for a 1.5 to 2 hour session. Was she ineligible? Nicole, it looks like Komoroski did put a request in the kiosk for DAO DAS services in October of 2023. Okay. So that's that. Now let's see what else we've got to talk about. So we've got things we've got to talk about. Okay, now the woman who accused Jay-Z of R-ing her is admitting there's inconsistencies in her story. So, the Alabama woman who accused Jay-Z and Diddy of R-ing her when she was 13 sat down with NBC News to recount what she called a catastrophic event: a limo ride to a White House, a drink that made her feel woozy, an essay by rap stars that would ruin her life. But the woman and her lawyers also acknowledge that there were some inconsistencies in her account in response to questions from NBC News. She said, "I have made some mistakes and recollections of that night." She's identified as Jane Doe in the lawsuit filed against Diddy and Jay-Z. The woman said she stands by her allegations overall. The inconsistencies in her account of the incident alleged to have happened 24 years ago do not necessarily mean that the allegations are false. Among the inconsistencies, the woman said her father picked her up after the alleged essay, but he says he doesn't recall that. The woman also claims she spoke to a celebrity at the after party where she said she was essayed, but that celebrity said he was not in New York at that time. And images from that evening show Jay-Z, whose real name is Sean Carter, and Sean Diddy Combs at a different location than the one the woman described. Although their whereabouts for the entire evening are unclear, this incident didn't happen, Carter told NBC News in a statement Friday, and yet he filed it in court and doubled down in the press. He added, referring to one of the woman's attorneys, Tony Busby, true justice is coming. We fight from victory, not for victory. This was over before it began. This 1-800 lawyer doesn't realize it yet, but soon. Okay, let's see here. The woman, who is 38 years old now, told NBC News she was living in Rochester, New York in 2000, and that attending the VMAs was on my bucket list at 13. I was like, oh my gosh, one of those things I've got to do, she said as she snuck out a window to evade her parents. A friend drove her down to Radio City Music Hall, and she watched some of the shows on a jumbotron outside. She also started chatting up limo drivers. I'm trying to get in to try to stay back and get to an after party and get invited in and meet some celebrities, she told NBC. One limo driver said he worked for Sean Combs and that she fit what Diddy was looking for. And he told her to return later and he'd take her to an after party. After about 20 minutes, hold on, 20 minutes in the limo, she arrived at a large white residence with a U-shaped driveway. She said in the suit she signed a document that she didn't read. Inside, she told NBC News, I'm talking to like Fred Durst, Benji Madden about his tattoo, because you know about his tattoo that the Last Supper, because I have a religious background, so it was just something to talk about. After accepting a drink from a waitress, I started to feel funny. I tried to start looking for a place to lay down. She found an empty room with a bed in it, she said in the suit. And soon after, Combs, Carter, and a woman entered the room. You are ready to party, Combs said. Both Combs and Carter eyed her, she said. Jay-Z comes over, holds me down. I started to push away. He puts his hand over my mouth, tells me to stop it, to cut the shite, and then he R's me like he had me overpowered. Afterward, she said in the suit, she managed to flee the house and run to a gas station. I was upset, and the person at the gas station could tell I was obviously upset. And she let me use the phone. I called my dad because he was the only person I trust at that time. I told him I messed up, I needed a ride home. We rode home in silence. He didn't ask what happened. He didn't ask me what I did or where I was. She told NBC she never told anyone about the alleged assault or wrote it down in a diary, even if someone found out, who was going to believe me? I mean, it was the word of two celebrities against mine. She now has 2 children, a son and a daughter. She served less than a year in the Army National Guard and left with the rank of private. She got her high school diploma and got her Christian counseling certification so that she could help people. The years after were hard. She said, I got severely depressed. I withdrew completely. My grades started slipping and she dropped out of school. She experienced homelessness, she said, and at one point suffered a head injury. She and her father also said she was hard later in life. That's all I can do tonight. I'm just tired. I'm going to do the, because I've got a lot to do tomorrow. I want to try to get my tree up tomorrow. I have to get everything packed up tomorrow to get shipped out on Monday. And then I have to get billed for things. I've got a lot to do, so let's do a word. Word cookies. Okay, daily puzzle. Daily puzzle, I see one thing. Punched. That came right out. And then we've got punch. This is how we unwind around here. And we've got den. And we've got dune. And we've got hand. And we've got pen. And we've got Good. We've got up, and we have, let's see, do. Okay, and how about do, oopsie, hold on. Do, Q, dunce. Okay. And let's see. You got nude, okay, and I just looked at your thing, okay, nude, yeah, nude, okay, no, but it's not there though. Okay, Q I already have up there, right? Yes. I'm looking at your words now. June I've already have. Okay. Pun. Okay, let's see. Oh, I know, cued. Okay. Un. Done. Okay. Oh, and. There we did. We got it. We got it. We got it. We got it. Ah. Did it, did it, did it, did it. Very good. Guys, I have to I hate to tell you, but I gotta go to bed. I just have to go to bed. Hi 61, how are you? Let's see. Alright, I'm going to let you go, guys. Thank you for watching. I appreciate it. Oh my goodness. Okay, I'll see you tomorrow. Everybody be good. God bless, prayers, and I'll see you tomorrow. Be good.